Bhaskar and also noted the statements of various witnesses. Which Lordship will find from paragraph 36 onwards.
Page.
Page 116, statement of witnesses. So I'm not taking your Lordship through this statement because these statements I have already played.
Yes, yes.
The documents which, but 1-2 lines I would like to place only. From the paragraph 38. Paragraph 38, page 127, next page. Police official Tulumoni Dwara, that is PW2, last 3 lines. This witness stated the names of some of the persons who were present at the gathering, which was also included the name of A2.
Just a minute, please.
No,
Page 2, dollar first or tinta line. Yes.
A2. This is in respect of the second accused, Lordship. Third accused. A2 Jagjit Singh, then Bhaskar Phukan. A1 also, 4th line. He further stated A1 and his associates had obstructed the police and government officials for performing their duties. Then this witness stated the names of some of the persons who were present in the gathering, which also included names of A2 Jagjit Guhai, A3 Bhaskarjit Phukan, and A4 Sri Bhupen Gogoi. So he specifically named A1 was present and he was obstructing the police and government officials for performing their duties as well. Prior to that also, this witness, about 6 lines from bottom, this witness further stated that associates of A1 damaged the white Bolero vehicle on duty under CRPF and turned the vehicle on its side. He further stated that they were all obstructing. Then Roman 3, witness number 30, Deborikis Chetia in his statement stated that on 9/12/2019, in the evening at 5:46, the local people started gathering near Sabwa railway station and leaders from various associations, including KMSS, began to deliver lectures against CAB, and that A1, Okhil Gogoi and others delivered aggressive, provocative speeches. Then Lordship will see the last few lines. A4 and other protesters nearly damaged vehicles, and that when the witness tried to remove one burning tire from the road, A2 Bhaskarjit Phukan hit the tire with a sword he was carrying. This witness further stated that A1, A2, A3, and A4 were leading the mob. I am also trying to emphasize on 2, 3, and 4 also today because the case is also against them. Thereafter, Lordship will kindly come to page 131. This is regarding the documents. Upon perusing the documents submitted as part of charge sheet, I find the following as regard to A1 Okhil Gogoi. I'm skipping 1, 2, and 3 Roman. Number 4. D15 are transcript of the intercepted telephonic conversation of A1 with various persons at the relevant time. In the conversation of A1 with Paramananda on 7/12/2019 at 21:50, A tells other persons about his plan to go to Chabua on 9 at night as public program was being planned thereof. In the conversation of A1 with one Boisho on 7/12/2019 at 22:18, they talk about the upcoming program at Chabua. In his conversation with Dibon on 9/12/2019 at 8:16 a.m., A1 asked him as to at what time he should reach Sabua, whereupon the other persons tell him to reach at about 7 p.m. In his conversation with Deep Duty on 9/12/2019 at 10:17 a.m., A tells about the evening program in Sabua. In conversation with Jagjit on 9/12/2019 at 4:20 p.m., the other person tells A1 that 5,000 people have gathered in Sabua, whereupon A1 tells him to call him after the program starts. In the conversation of A1 with Jagjit on 9/12/2019 at 5:28 p.m., they talked about the gathering of 7,000 to 8,000 people, and A1 says that he is on his way. In conversation with Chandan Gogoi on 9/12/2019 at 5:29 p.m., A1 tells that he is at Chabua and will stay there whole night. Then Lordship will Roman 6 D29 is the scrutiny report of video seized by production cum seizure memos dated so and so, serial number 367. Therein are speeches delivered by A1. Serial 8 is stated to be a video of police officers with grievous facial injury, and behind the police party is seen crowds shouting slogan Joya Yachom. Next page. D33 is a production cum seizure memo dated so and so, wherein one of the item at serial number 7 is 6 number of photographs showing Mohendra Bolero number so and so is capsized condition. D45/5 pertains to some assessment of loss of railway properties during the CAB protest. D48 is a photograph identification in which 6 photographs are indicated, out of which photograph A and C are of A1 and photograph E and F are co-accused Bhupen Gogoi and Bhaskarjit Phukon. Then D49 is the CPR analysis report of the mobile phones of the accused persons of the case and others in connection with the alleged incident. It is stated that A1 connected with accused A2 from his mobile number so and so. It is stated that CDR analysis revealed that on 9/12/2019 at 5:29 p.m. to 8:15 p.m., the tower location of A1, that is Akhil Gogoi, with his mobile number so and so was found near the tower location covering the area of Sabua under Dibrugarh district. It is stated that CDR analysis also reveals that on 9/12/2019 at A1 reached Panitola in Tinsukia at 1 p.m. and at 5:39 p.m. his tower location was found in the area of Sabua, that there was no CDR activities between 5:39 to 7:53, and that the same indicated that the accused has deliberately switched off his mobile during this time, and from 7:53 to 8:15, the tower location of mobile A1 was again found in Sabua area. It is further stated that CDR analysis revealed that A1 was at Sabua on 9/12/2019 at the relevant time, and the tower location of co-accused A2, A3, A4 were also found in Sabua area during this time, like that of A1. So that switching of the mobile also bears some significance. One can always come up that the battery got drained off, but at the same time we have the other side also, that deliberately to remove his presence from that locality, he could have done it also. So all these things will come out in the trial. Then regarding A2 Roman 41 Roman 2 are there. Then regarding Bhaskarjit Phukon 42 Roman 2 is there. Then page 134 Roman 4 document D75. I'm only taking the very relevant ones. In fact, all are relevant, but these have more importance, significant. Document D74 is a scrutiny report dated 26/6/2020 of video seized from cyber cell of SP Office Dibrugarh in connection with the instant case. It is stated that against serial number 1, the video mentioned revealed one white gypsy vehicle of ITBP bearing registration number so and so being attacked by violent mob, and when the vehicle tried to speed away, some violent protesters ran after it and attacked it with club, pelting stones, etc. It is further stated that A3 Bhaskarjit Phukon is seen leading the protesters and carrying one sword in his hand. Now, analysis part, Lordship. Next page, 135, paragraph 45. Among the witnesses examined by police during investigation, I find protected witness A, witness number 2, 3, 17, 18, and 30 are some of the eyewitnesses. So they are not all. So beyond that also, there are other eyewitnesses also. Are some of the eyewitnesses to the alleged incident. All these witnesses have stated that on 9/12/2019 in the evening, there was a large gathering at Sabua near Sabua railway station, which was also addressed by A1, and that he gave provocative speeches there, and subsequently the crowd turned violent and started pelting stones, one of which hit the witnesses number 2, Tulumoni Dwara, informant cum victim, grievously injuring his face and teeth. The nature of the injuries sustained by the informant is clear from the medical evidence on record and statement of witness numbers 19 Dr. C.R. Joshi, a dental surgeon of Dibrugarh. The witnesses have not stated that A1 has directly incited the violence, but they have stated that he delivered provocative speech whereafter the crowd turned violent. Protected witness A1 has also stated that after the crowd turned violent, A1 did not denounce it or did anything to stop it. Witness number 2, informant cum victim, has also stated that after sustaining injuries, he was being shifted away from the site. A1 was still addressing the gathering. In his statement, witness number 18, Biswajit Phukon, a TV journalist, stated that after the vandalism, A1 and others remained at the site for an hour, and this witness did not see A1 requesting the crowd not to vandalize. Pausing here for a moment, Lordship. If we look at the statements and the observations made by the learned trial judge, Lordship, it is sufficient to make a charge here. There is no reason to disbelieve the protected witness number 2, 3, 7, 18, and 30. These are all credible witnesses. If they are not credible, that will come out during the cross-examination during the course of trial. And these all witnesses, although the learned trial just said some of the eyewitnesses, so there are beyond these persons also, there are other eyewitnesses also giving statements. 35, 36, lot of others. So why he have selected only these 5, 6? His own statement are some of the eyewitnesses. That means there are more persons who were eyewitnesses to the incident. And there is no reasons to disbelieve the statements given by the victim informant and the other person, including a journalist. And they are from different status. And some of them are organizers along with A1. So they are the co-organizers. Reading further, paragraph 46 now. Witnesses like, so it is very casual when a finding has to be given by an honorable court on a very serious matter like this or any other trial, because every criminal trial is a very serious matter for the person concerned. For A1 also, this is a very serious matter. And for NIS also, it is a very serious. So the learned single judge when said some of the eyewitnesses are saying this. Now here he says, witnesses like witness number 5 and 8 have stated that crowd led by Akhil Gogoi started pelting stones. So crowd led by Akhil Gogoi. What is how he can have a different opinion than a single trial judge? So 5 and 8 says crowd led by Akhil Gogoi started pelting stones in the police party, but some of the other witnesses, who are those? No indication. Who are those? So some of the other witnesses have stated that Akhil Gogoi delivered an aggressive and provocative speech, and subsequently some members of the crowd started pelting stones at the police party. So 3 different factual situation here. But all leads to one thing, that violence had taken place. Akhil Gogoi was present along with A2, A3, A4. There was provocative speech. Whether that provocation was sufficient to incite the people to indulge in vandalism, that will come out during the trial, Lordship. But this is prima facie a case. Everyone is saying that once Akhil Gogoi started arriving, he had arrived at around 6 o'clock. The mobile tower says so. People started getting agitated. And these are statements of people who are along with him, who are the police and who are the bystanders. Everybody is saying the same story. Therefore, may I read further? I find some differences in the nature of the incident. So, some difference, whether that some difference is sufficient to discharge a person,
This you have pointed out on the last occasion.
because I am going to go further, Lordship.
You had also contended that it doesn't appear that there is inconsistency. It appears that
It's a continuation, it's a sequence of events.
There is no-
I read up to 47, then Lordship, the other year court rose. So I want that continuation part, that's why I take your Lordship to this. Therefore, I find some differences in the nature of the incident narrated by these 2 sets of witnesses. So there are 3 sets of witnesses, not 2. From the first paragraph itself says 3 sets of witnesses. Further, several of the witnesses, then this is the 4th situation. Further, several of the witnesses have stated that they could not recognize the protesters who had thrown stones at the police party, leading to injuries on the Sabua police station, OC Sabua police station. So, some protesters were not identified. But whether that will give clean sheet to the persons who have perpetuated this offense, though they can always come in if the trial court and during the examination in chief or cross-examination, new names appear, then the Honorable Court is quite empowered under the statute, under the procedural law, criminal procedural law, to induct them into the trial. Reading further, the statement of witness Deboraki Chetia, that is PW 30, that the accused person, including A1, was leading the mob, is not corroborated by similar statement on the part of other witnesses about the accused persons leading the mob. I strongly object to this, because if Lordship is pleased to look at PW 17, PW 17, he also says the same thing. So Deboraki, he's a journalist, no, he's a organizer. So Deboraki says that A1 leading the mob is not corroborated. Now, if Lordship is pleased to look at the statement of PW 5 and 8, 5, 8, 17. They also said the same thing. If Lordship is pleased to come to PW 5, page 15. About 6 lines from below, at around 7 p.m. Have Lordship got it? At about 7 p.m., some agitated people led by Akhil Gogoi started throwing stones at the police party. Even others also said the same thing. 8. No, no, again, in this next page, PW 6, about 6 lines from below, when we, along with district administration and OC, tried to clear the road, have Lordship got it? At 7 p.m.,
Page.
Page 100 and only 16.
PW6.
PW6. When we, along with the district administration and OC, tried to clear the road around 7 p.m., some agitated people led by Okhil Gogoi started throwing stone at us. So he is a direct eyewitness and he is at the receiving end of the stones. Good. Yes. Now PW9. I am the VDP president. Yes. Page 19. Second line, I am VDP president of Sabua town on 9/12/2019. A rally was held at Sabua under the leadership of Okhil Gogoi to protest CAB with around 700 to 800 people gathering to carry out a rail blockade program. So Okhil Gogoi led the whole program. Previous page also identical statement is there. Then Lordship will kindly come to PW 11. No, PW 10, 11, everybody said the same thing, Lordship. PW 10, my name and address as above. I am VDP so-and-so of Sabua. A rally was held at Sabua railway station to protest against CAB under the leadership of Okhil Gogoi at around 7 with about 7 to here with the intention to execute a rail blockade program. Next page. Again, Okhil Gogoi, led by Okhil Gogoi, third line. PW 11. PW 12, page 23. About 10 lines from below. At about 6 p.m., Okhil Gogoi, leader of KMSS, created a tense situation. So Okhil Gogoi directly created a tense situation at the place of the rally by delivering a long speech against CAB, criticizing the directives of the government BJP and thus instigating people present there to execute rail blockade program as part of economic blockade. So UAPA comes straight away here. No reasons to disbelieve. Then, by provoking people present there to build a violent movement. Immediately after that, some people from the rally tried to stop the vehicles flying on the highway by pelting stones, thereby damaging them. And when we, the police personnel, tried to resist them, the agitated public attacked the police also. As a result, OC sustained grievous injuries. Then next page, PW 13. This is a statement of Lokhikanta Bosumatari, 7 lines from below. In his speech, Okhil Gogoi urged the people to disrupt the functioning of all government establishment in Assam in order to paralyze the government machinery.
In 24, come to 24.
Yes.
Second line. Second line, provocative.
Provocative speech of Okhil Gogoi, the leader of KMSS, against the government is the main reasons for occurrence of this incident. What more is required, Lordship? These are the things. I am not saying that this is 100% or sacrosanct. But this has to be tested in a trial. We are not asking for convicting him. At least he should face the test with these witnesses, with these evidences, with this material before the court. And if he comes out clean, we'll be more than happy. But that is not the case. Next page, PW 13. In his speech, Okhil Gogoi urged the people to disrupt the functioning of all government establishments in Assam in order to paralyze the government machinery and to stop flying of vehicles on the national highway. It is in its aftermath, the enraged crowd vandalized several structures in Sabua, including railway station, post office, UBI circle office, UBI bank circle office, and the residence of local MLA by setting them ablaze. So this statement, these observations of the learned trial judge in my humble and respectful submission in paragraph 47 is totally incorrect. Then coming to 17 also very clear. Statement of Biswajit Phukon. Page 32. Oh, no, this is page 17 of person. Page 17, Dhruva Bora's statement. Here also, IO duty protest program was undertaken by the people of Sabua under the leadership of Akhil Gogoi. In his speech, instigated people of Sabua, and as a result, the crowd started pelting stone on us. Page 30, last 4 lines. And one stone hit OC Sabua. The next 17, statement of Biswajit Phukon. He is a local correspondent of Proceedings Time. He very categorically stated, my name and address is stated. I am a local correspondent of Proceedings Time during CAB, which has become CAA now. I was in Sabua on 9th of December. Assam Band was called. Assam Band call was given by Krikhak Mukti Sangram Samiti and other organizations. On that day, at evening time, there was huge gathering at Sabua town, comprising of 6,000 crowd. Akhil Gogoi and some of his companions arrived at the meeting venue at 6 p.m. The meeting was arranged near the Sabua railway station. As soon as Akhil arrived, he asked the people to sit on the railway track to block the rails. After some time, while the provocating lecture of chief guest Akhil Gogoi was going on, people get more furious and started pelting of stones upon the security personnel. Seeing the hue and cry, I rushed towards the main road on NH 37, where the security personnel were mainly present. On the way, I saw OC of Sabua, PS Tulumoni Dwara, sustained injury on his face and was bleeding. He told me that he was hit because of pelting of stones by the supporters of Akhil Gogoi. I took the video footage of the injured OC as well as the meeting environment. Akhil's lecture was still going on. There was no peaceful environment, although the environment was already noisy. One bolero was also damaged there because of the instigational speech delivered by Akhil Gogoi. So, Lordship, in my humble submission, I do not have to place anything more to counter the observations at paragraph 47, where the learned trial judge said the statement of Deborakhi Chetia that the accused person A1 was leading the mob is not corroborated by similar statement on the part of other witnesses about the accused person leading the mob. So this is totally contradictory to the statements which I have just placed. If I go further, I will find more such statements from the witnesses. And this is contradictory to paragraph 46 also. Further, some of the witnesses attributed vandalism on the part of protesters instead of attributing to A1. That means some has attributed to the protesters, the others attributed it to A1. So whether A1, if this second line, Lordship, some of the witnesses attributed vandalism on the part of protesters instead of attributing to it to A1. That means the other some is attributing it to Akhil Gogoi, A1. So whether that will lead to this discharge. Some of the witnesses have also stated, this is the third version now. Some of the witnesses have also stated that they do not know the attacking persons, and some other witnesses have stated that they could not recognize the attacking protesters in the dark. Some witnesses have simply stated that some protesters in the crowd pelted stones. So videos, photographs, etc. are there. One was branding a sword, others are branding lathis. We have all the photographs. We can show it to this honorable court. We have no reservations on that. So this whole paragraph as well as paragraph 46, in my respectful submission, is totally perverse without any proper justification of these findings. Now, going further, paragraph 48, in the context of the statements of few witnesses that A1 gave provocative speech to the crowd which turned violent, the content of the speech available in document number D29 is most important to correlate the two. In this regard, upon perusing the speeches of A1 from D29, I find that though it contains some sharp political statements and criticism with regard to CAB, there is no incitement to violence. I also do not find incitement, instigation to damage property or obstruct public officials. Considering the content of the speech available in D29 and the statement of the witnesses about provocative speech, it appears that the tone and tenor of the speech might have been aggressive on the issue of CAA rather than the speech directly inciting violence. After noticing the content of speech of A1 from D29, I find a contradiction of the statements of one or two witnesses about A1 leading violence, mob throwing stones. So this is a very casual observations made by the learned trial judge, Lordship. If I have already placed the speeches the other day, 3 specific lines were there. If Lordship, once I can place it once more, that 3 lines from the speech, which clearly indicates it is provocative and it is a warning thrown to the people or to the society. Speech कहाँ गया? इस पे था ना? Mark for us. किमान पेज होता है पेज नंबर person. I'll come to those speeches, Lordship. Now, paragraph 49. If the content of the speech of A1 Okhil Gogoi do not contain instigation of violence, etc., simply the statements by some of the witnesses that A1 giving provocative speech leading to violence could not be relied on in my considered view to impose criminality on A1 Okhil Gogoi. In the large gathering where speeches are delivered on contentious issues, it is possible for the crowd to get excited and some unruly elements therein might take undue advantage of the situation to indulge in unacceptable behavior. The omission on the part of A1 as revealed by the statement of some witnesses is that after some vandalism started, he did not do anything to stop it. However, in my considered view, that it itself would not impose criminal liability on him, A1, though it might have been his moral responsibility to try and do something about it. I fully contradict this view because section 149 of the CRPC, I would like to place under judgment of the Supreme Court on that particular provisions of law. His presence is sufficient there. One mark one page number? Page 274. Lordship, 274 regarding the speech. Then I'll come to this 149. 274. 274. Next page D7, D29 here 274 first his speech delivered by Okhil Gogoi from it as a Assamese translation. It is translated to English. Here he said, I want to invite him, that is the present chief minister. I wanted to invite him in Sabua. I wanted to invite so-and-so once. Leave your jet category CISF persons and come to Sabua to see the movement by wearing color glass of BJP, RSS, etc. So when he says that you come without your security, then you will face the consequence. This is the meaning. Then next page, Lordship will kindly see. Last 4 lines. Video 7. I call everybody to unified ASU, KMSS, AJYCP, all nationalist organizations of Assam, leftist organizations of Assam. These organizations are banned organizations, Lordship. CPI-ML. From 2009 onwards, they are banned, leftist organizations. and all political parties unified for the movement against CAB, and till CAB has not been cancelled, we will not spare anybody. This carries the meaning that unless you remove the CAB or repeal the CAB, till that, if you don't do that, then we will not spare anybody. And that statement, followed by the vandalism, attack on police, attack on vehicles, burning of railway station, burning of BDO office, burning of bank, followed thereafter. So we are not going to spare anything. In Latasil, a meeting is going on. Same thing has been said. We will not spare anything unless CAB is removed and the people come to High Court and damage the High Court building. Whether that is incitement or not. It's a plain and simple sequence of event. You don't have to say that go and break the High Court or damage the High Court or burn the railway station. This is sufficient. The language and what actually followed thereafter. Throwing stones at police. Page 319, Lordship will kindly see the photograph. Part 2.
(319).
319 onwards.
Yes.
The gentleman is giving speech, not before the, but before the media at the same venue. Page 319, then Lordship will kindly come to page 321. So the person who was standing with him was carrying a lathi. These are all recorded documents. These will be part of the trial. This is not a sign of non-violent movement. One, then page number 324, removing the cover of the sword here. And the sword photographs also we'd like to show. Put a photo. So lathi, sword, everything was there in presence of Okhil Gogoi, A1, and other persons. One of the accused, A3, was actually carrying the sword. So this statement requesting the leftist organizations also. And before going to 149, Lordship will kindly come to page 313. This is an order of the District Magistrate, Dibrugarh District, issued on 31st of October 2019 under the provisions of CRPC 144, banning assembly of people and various other acts. So this was issued on 31st of October 2019, and thereafter it is in force for next 60 days. That is the law. Lordship knows that. 144. After 60 days, it goes away unless a fresh notification comes. So the incident happened on 9th of December. So it is within that period of 60 days. And thereafter, Lordship, during the investigation, we try to verify whether there was any order of 144, and therefore we received a communication on 11 June 2020 during the investigation, 315 page number. It is issued by the Additional District Magistrate Administration Dibrugarh to the Chief Investigating Officer NIA regarding permission. With reference to the subject cited above, I have the honor to inform you that no permission was issued to KMSS on 9 December 2019 from this end as per record. So there was no permission granted. That is why I am saying that this is an unlawful assembly. So there is a disobedience of this order. Section 188 should have been incorporated in the charge sheet. That was not done. But in any case, I am not on that now. It can be always added. 149. Lordship will kindly see. CRPC. IPC. IPC. Yeah, IPC 1. One 49 says of IPC, every member of unlawful assembly guilty of offense committed in prosecution of common object. If an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or as such the members of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing of that offense is a member of the same assembly is guilty of that offense. And Supreme Court has elaborated this provision. 2024 9 SCC, page 314, Nityananda versus State of Uttar Pradesh, paragraph 43 to 47. IPC to namana kana moita kosto koribo loga. IPC no hobli koi dila na etu kana koi subo lage. So paragraph 43, Lordship, at page 324. This brings us to the pivotal section, which is section 149 IPC. Section 149 IPC says that every member of an unlawful assembly shall be guilty of the offense committed in prosecution of the common object. Section 149 IPC is quite categorical. It says that if an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the member of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing of that offense is a member of the said assembly is guilty of that offense. Thus, if it is a case of murder under section 302 IPC, each member of the unlawful assembly would be guilty of committing the offense under section 302. In Krishnappa versus State of Karnataka, I am reading the quoted part. It is now well settled law that provision of section 149 IPC will be attracted whenever any offense committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or when the members of that assembly knew that offense is likely to be committed in prosecution of that object, so that every person who at the time of committing of that offense is a member will be also vicariously liable and guilty of that offense. Section 149 creates a constructive or vicarious liability of the members of the unlawful assembly for the unlawful acts committed pursuant to a common object by any other member of that assembly. This principle ropes in every member of the assembly to be guilty of an offense where the offense is committed by any member of that assembly in prosecution of common object of that assembly, or such member or assembly knew that the offense is likely to be committed in prosecution of that object. The factum of causing injury or not causing injury would not be relevant where the accused is sought to be roped in with the aid of section 149. The relevant question to be examined by the court is whether the accused was a member of the unlawful assembly and not whether he actually took part in the crime or not. So his presence is sufficient.
Overt act is not necessary.
Overt act is not necessary, Lordship. So up to paragraph 47 and another judgment also, I'm just giving the reference. The other one is 120B, that conspiracy part. 120B IPC, punishment for criminal conspiracy. Whoever is a party to a criminal conspiracy to commit an offense punishable with death or rigorous imprisonment for of a term of 2 years or upward shall, where no express provision is made in this code for the punishment of such a conspiracy, be punished for in the same manner as if he had abated such offense. Whoever is a party to a criminal conspiracy other than a criminal conspiracy committed an offense punishable as aforesaid shall be punished with imprisonment of either descriptions for a period not exceeding 6 months, or with fine, or with both. So the whole assembly, all the people were against the common object, that is protest against CAA at that point of time. So Akhil Gogoi or A2, A3, A4 cannot say that we have a different object than the people who have gathered there. They have all violated section 144 of the CRPC. No permission was taken. There is a direct violation. Section 188 also comes there. And the people who were present and during that time, A1 as well as other three were also present. From the evidence of various statements, we can gather it. From the mobile tower location, we can gather it. And eyewitnesses, everybody is saying the same story. And he himself has spoken to his colleagues during the telephonic conversations, which have the CDR record analysis. So this will definitely be part of the trial. So regarding 120B, section 2024-10 SCC, page 651, Ram Prakash Chadda versus State of Uttar Pradesh, 651, paragraph 30, 31, 32. So I do not have to read because these are fundamentals, Lordship.
Paragraph 30.
30, 31, and 32. Or if Lordship, I can read it. 30, 31, 32. Now coming to paragraph 50, Lordship, page 138 of the judgment. Paragraph 50, 138. As far as the documents with regard to A1 are concerned, D15 contains the transcript of telephonic conversation of A1 with various persons. D49 is the CDR analysis report of the mobile numbers of accused person, including A1. The telephonic conversation and CDR reports no doubt indicate that A1 was present in Sabua. So that unlawful assembly is established here itself. The telephonic conversation and CDR reports no doubt indicate that A1 was present in Sabua on 9/12/2019 and also about organizing protest against CAB. So that conspiracy part is also there. However, from the telephonic conversation, I do not find anything incriminating regarding any commission of offense or any conspiracy.
Transcripts are there,
Transcripts are there. I have placed it already.
which Mr. Bhattakur is emphasizing that from the speech and the transcripts, offense does not appear to be made out. That is his main-
We have to see, one is planning, then next is speech, and third is the action, the sequence of events. 1 and 2 we cannot ignore and straightway go to sequence number 3. When he says that unless CAB or CA is repealed, nobody will be spared. railway station was not spared, police person is not spared, the ITBP personnel were not spared, they were chased in their vehicle. It was turned upside down. The local MLA's residence was not spared. The bank was not spared. The circle office is not spared. So these are the consequential action. So to do that kind of offense, you have to have a gathering. So he organized that gathering. Then he will have to motivate that people, those people who have assembled. That motivational part he have indulged. If he had given a speech saying that no violence is allowed, we'll do it in peaceful manner. That was not the case. When he says, let the minister come without his security and he will see, he will face the consequence. That means if he has nothing against a physical attack, then he would have said that he can come in any manner, with security, without security. But when he specifically says, come, but without security, then you will know. That is the inner meaning. Any common person will understand that when I say, khali hata diya, what does it mean? Don't bring your gun. The children also, when they fight, come with your empty hand, bare hand. Everybody understands the meaning. So we cannot ignore all these speeches. We have to read between the lines and we have to read the words in its literal meaning as well as here its consequential meaning. It may look very naive, but the message which he is saying that unless CAI is removed or repealed, till that time we will not spare anybody. And at the same time, he says his colleagues attack the machineries, attack the in his television, in his telephonic conversation, close the highways, stall the state machinery. Those were telephonic conversations. Raise a protest before the Prime Minister of Japan. Go for all these different kinds of protests. So we cannot ignore all these things, Lordship, in my humble submission. So there may not be a word that go and burn the railway station. But whatever he has says, it has led to burning of the railway station. Arson is a very serious offense under the IPC. So now coming to paragraph 53. In view of the materials on record, as discussed above, I am of the considered opinion that the omission and commissions of A1 revealed by the materials cannot be prima facie said to be a terrorist act done with the intention of threatening unity, integrity, sovereignty, and security of India, or a terrorist act done with the intention to strike terror in the people. Statements of PW 41 and 42, who are residents of Amrapali, a Bengali dominated area. That area was attacked. The statements he has given, the people from the meeting went to that area. Those were not discussed. He has noted, but he has not discussed. Railway blockade. All the witnesses are saying that once he started coming to the meeting place, Lordship, immediately people went and all sat on the railway track. And some of the statements saying that it was not a part of speech. Everything is not in the part of speech, but he said that he asked the people to go and squat on the railway tracks to stall the railway movement. Those were statements, those were not speeches. It is not that only speech. Speech is one component of the investigation. What he is saying to the other people who have assembled and who are part of his organizations, they are saying this. Protected witness, I do not know his identity. Lordship will, he himself says, protected witness A1. Protected witness, this studio. protected witness. No? Full area. Okay. Page 8. Paper book 1, no? Page 8, Lordship, protected witness. On being asked, I have to state that on 9/12/2019, Okhil Gogoi, founder member of KMS, called me. So he was invited. Called me and asked why me and my supporters are silent. Further, he provoked and told me to do something fiery. Categorical statement, Lordship. These are not speeches. I replied him to join. After some time, I joined him, and at around 1800 hours, that is 6 p.m., we reached at Sabua. There was a large gathering, and atmosphere of the meeting place was very noisy. After reaching Okhil Gogoi, the mood of the crowd got more charged. However, Okhil addressed the meeting. During his speech, Okhil provoked the people and asked them to oppose the government using any means, whether they had to do anything for it. Due to his provocation, some people from the crowd started pelting stones on the security officials. One of those stones hit on the mouth of Tulumani Dwara. He got grievously injured and 2 of his teeth were broken and was bleeding profusely. Even then, the crowd did not stop and overturned and damaged the Bolero vehicle on the road, probably of government duty. Even after that turning of crowd violence, Okhil Gogoi did not denounce the same or did anything to stop them. I have shown transcript of my telephonic conversation with Okhil Gogoi on dated so-and-so. In this regard, I state that my telephonic conversation with Okhil Gogoi and all the contents which are mentioned in this conversation are correct. And PW 18, that journalist of Proceedings, he said, as soon as Okhil arrived, he asked the people to sit on the railway track to block the rails. So this is not a part of speech. Speech is only one mode of his incitement. The others is that he is directly speaking to the people. So all the persons there said that he has told this. So those who have heard it, those will be found out during the trial. So coming back to the judgment once more, the last part, or say I'm almost closing. Page number the judgment of 137. Yes, paragraph 53. I was this. Now coming to paragraph 55, 141. Despite the statements of informant Tulumani Dwara and Deborikhi Chetia, in view of other materials on record, I am of the considered view that it is not possible to come to a prima facie findings for the purpose of framing charge that A1 was part of an unlawful assembly. This is straightway a perverse finding. A1 was not a part of unlawful assembly which injured the informant, and therefore it would not be justified to try A1 for offenses under so-and-so, so-and-so, so-and-so. Paragraph 56. On the basis of the materials, I also do not find a prima facie case for the purpose of framing charge to hold A1 personally criminally liable for offenses of rioting, unlawful assembly, causing damage to property, causing hurt to public officials. Where will section 149 go? We have placed everything, including that order of 144 CRPC promulgation. Thus, on the basis of the materials, I am of the considered view the same is inadequate to frame charge against accused for the offenses of IPC narrated in the charge sheet for other IPC offenses. So, there are sufficient materials against A1 and identically in all the cases, A2, A3, A4 are also present. They are also equally responsible. Okhil Gogoi's additional input is that he was giving speeches, but the other persons were part of his same organization who was part of organizing the event on that day. They were part of the mob. They were part of the crowd. They were even indulged in pelting stones also and brandishing sword. Against him, the charge has been framed. Only one person, but others cannot be discharged. And section 188 of the IPC, which is not a part of the charge sheet, but that can always be added later on.
What is it?
Disobedience of order duly promulgated by public servant.
The 144.
144. So in that view of the matter, in my humble submission, there is sufficient materials to set the ball for rolling to conduct a trial. It is not a fit case for discharge. And in that view of the matter, in my humble submission, the impugned judgment is not only perverse, it is unrational, illegal, and totally devoid of any merit. And therefore, this honorable court may be pleased to set aside that judgment. And if Lordship feels that charge can be framed here, it can be framed, it can be done here also, or it can be remanded back for fresh hearing. Because in the other case, it was done in that manner. That's why I'm making that submission. But I am leaving that scope to this honorable court, to the wisdom of this honorable court. And I'm deeply obliged for giving me a patient hearing, deeply obliged.
We'll have those speeches.
Yes, Lordship, my friend will be
demonstrated.
there. So may I take leave, Lordship?
Yes, yes.
Because I have to-
We'll have the proceedings in camera.
আমি আর আরম্ভ নকৰিবা দেই। আমি আৰু আৰম্ভ নকৰিবা,
No, no,
মই ক'ত থাকিব লাগিব?
I will just, your lordship, two judgments, your lordship, have in the meanwhile found your lordship.
Regarding what?
Regarding this is a relatively new judgment on framing of charge to 2024.
Please sit us. Otherwise, we have heard you extensively.
That is why I will not
Please
repeat
do.
it, your lordship.
Just please do.
One is 2024 6 SSC 591. This is not. 2023 13 SSC, your lordship. 2023 13 SSC page 54. Para 210 euros. Entire judgment, your lordship, I have not handed over, your lordship. It's a big judgment, your lordship.
Not it.
Para 210, your lordship, may kindly see. On that, your lordship, strong suspicions and the materials to corroborate the allegations.
Zakia Hassan.
Zakia Hassan.
Paragraph
Paragraph 210, 9 and 10, your lordship, 10 specifically.
2210.
10. Materials to corroborate your lordship, that is, and strong suspicion that has been laid down. This is one, and your lordship, another, your lordship, that is on terrorist act, your lordship. This is your lordship, 2024 6 SCC 591. 36. Para 36, one paragraph, your lordship.
2024.
6 SCC 591. One paragraph, para 36, your lordship. Para 35, your lordship, not 30. 34 and 35. 35 is the specific para. And finally, your lordship, one line, your lordship, I just want to add to what I have already stated, your lordship. That's, your lordship, that from this speech, your lordship, by taking out an isolated sentence, your lordship, criminality cannot be attributed. It will have to be read Your Lordship, in totality, together, Your Lordship. Now, Your Lordship, when he is giving a speech, asking for a debate, and then making that statement, Your Lordship, we cannot look at that particular sentence in isolation, Your Lordship. That's my submission, Your Lordship. Ultimately, Your Lordship. And so far as this leftist organization is concerned, Your Lordship, there are many leftist organizations, Your Lordship, which are in the electoral process, participating in the election, Your Lordship. And in fact, Your Lordship, the meeting was convened by one of the group, which, Your Lordship, is a part of the leftist political party, Your Lordship, CPM, Your Lordship. Therefore, Your Lordship, is need to be considered, Your Lordship, in its entirety, not in isolation, Your Lordship.
Means piece of symbol of offending species 45, 11:45, 11:15. We'll do one thing. We have concluded.
Lordship.
We'll assemble in the chambers.
Lordship, my friend will be there.
Yes, we'll like some representations, and we'll have the technical experts. We'll like to have the
Lordship.
videos as well as the transcripts
Transcripts.
in original, the vernacular. Okay.
And other two matters, Your Lordship, may fix in the month of May, or that will be good. 2 and 3.
Okay, 2 and 3, 2 and 6 that are indications. Huh? May should do it.
May what? Deeply obliged.
Because we say, CAV position, or we get another. Heard, huh? This assisted by Speak, and as well as your name? Satyanaran. For the appellant, also heard as brought up to know for the respondent. Here is concluded. Judgment is reserved. If your indication they do. Okay. I think we will also have a. Transparent activity. Oh, कुछ add कर देंगे. Yes, by you assemble by around 10 minutes at 11:50. We'll have our computer technical experts. Okay. And bring all the particulars.
নোটটো ভৰাই দিব দাদা এই ৰঙা বান্দলটো লৈ যাব ভিতৰলৈ ৰঙা বান্দলটো ভিতৰত লৈ যাব হৈ গৈছে ৰেডি কিবা আছে নেকি বেলেগ ইটা নালাগে টপলাটো লাগিব টপলাটো খুলি দিবা
নিজে উস্তাদি করে টেক করছি
বাইদেউ মেইল এটা দিছিল চেক কৰিব ফাৰ্ষ্ট আইটেম টোৱে
I don't supply what?
Demanda certificate of applicable for loans. Now, person by almost by never. Now, AMP.
Cosa? Yes. Yes. Itu guys,
Why the high file pushing to list all that? Yes, sir.
Why advice to
एक वहाँ आराम से किसी टाइम पे समझ
interest के दिवार है one person liter any suspension or against any civil PI बने हमें advice course as per law the suspend हो
ये कोई I will not go to this. Immediately. अब जो ताकत से आराम मारे वहाँ के जो सब पता कुछ नहीं वहाँ English adopt to
Last time they have taken time.
Let's
Yes.
take it right.
So, Malvik Nobel.
Procedural has been furnished a copy of this. Paper book has been prepared.
Yes.
Hear it.
That's also going to be done, my lord, only.
We'll hear it. Whenever you say.
I'm ready, my lord. Any day.
Today is, we can have it day after tomorrow if
Day
you
after
want.
tomorrow.
Yes, sir.
Day after tomorrow.
How many witnesses?
Witnesses, my lord, to tell
18.
16.
And
Bas-
one DW.
One DW. Basically, 3 or 4 persons are there, depend on 1 to up to
Conviction under 302.
is equal to 5 persons.
Eyewitnesses.
5 persons, there's no ayuta otherwise. By the torch they have seen, torch was not seized, my lord.
But somebody has seen with a torch.
Somebody they stated that after coming, we said that they are going away, they're running away.
No, not eyewitness of the incident.
Not in that sense, my lord.
They saw him fleeing
Yes.
from the flame.
Torch, my lord. But torch ultimately is found to be the torch belonging to the deceased, my lord. That which one seized, my lord.
And that was caused by what? That was caused by what? By injuries?
Oh, no, that's by sharp weapon, my lord.
Sharp weapon.
Sharp weapon. Land dispute, admitted land dispute, my lord. Admitted in the FIR itself says that there is land dispute on. It is a case, my lord, I think, your lordship, it will not take much time.
Heard Sri H.R.A. Chaudhary, Senior Counsel assisted by Sri I.U. Chaudhary, Counsel and Counsel for the Appellant. Also heard Ms. Bib here, learned APP. Paper book has been prepared. And the learned Senior Counsel has submitted that this matter can be heard. Considering the above, Registry is directed to list this matter for hearing on Thursday.
Obliged to watch.
We'll try on Thursday,
My lord, my lord.
26.
The earlier case also my paperwork prepared.
No, that aspect is there.
Ah.
POCSO,
Well,
that's one number 2.
ah,
We have to see whether
yes,
it's
that
served
is
or not.
different.
That is
Right, my lord.
Madam Rava, what is
Lordship,
this?
TCR not received lordship.
Hmm?
TCR was called lordship, TCR will not receive lordship.
Not arrived, that's what it is.
Dimitri,
I can see.
yes, DCR for files fixed.
Received.
Yes, madam.
Records have been received. What about the report, madam? From Parabhog PS? Have you received any report? POCSO,
Lordship, may I know who was the counsel who appeared?
just a minute, please.
Who appeared over?
R.R. Kaushik. Mr. Kaushik,
My lord, today morning I enquired in my office, my lord, the report has not
we'll
come.
grant you some time.
My lord.
Okay. Since the reports have, the records have come, we'll direct preparation of the
Yes,
paper book.
In the meantime.
In the meantime, okay?
my lord.
Madam, your B. Rabha,
P Rabha lordship.
P.
P Rabha.
Heard Miss P. Rafa, learned counsel appearing on instruction of Miss A. Khan, learned legal aid counsel for the appellant. Full stop. Pursuant to the order dated 21/1/2026, the TCRs have been received. However, there is no report from the concerned Horobhog police station with regard to the service of notice upon the response number 2. Para. While the office is directed to prepare the paper book, Sri R.R. Kaushik, learned APP, prays for and is granted 2 weeks' time to obtain the report, concerned report regarding service of notice upon the response number 2. For the list on, we give a date.
Oh,
2 weeks enough, I think, or we, no, we'll not get, have it 3 weeks. This Bihu break will be there. List on 24th of April.
24th.
Maybe.
Yes, where is Mr. Roy Chaudhary? What is this?
He is election 18, my lord. So we have appeared, my lord, and
What is
one
this?
IA has been filed, my lord. So
Okay.
please this matter along with this IA, my lord.
When did you file the IA?
So, my lord,
No idea.
yes, my lord.
You should know the date.
So there was an IA that was disposed on 26.
Actually, my
Then
lord,
24th.
we have newly engaged, my lord, in this.
Okay. What is your name?
S. Ahmed.
Sri S. Ahmed, learned counsel for the appellants, has informed this court that an IA has been filed in this appeal, which has not been listed. Also heard Sri R. Kaushik, learned APP, who has however informed that an IA was earlier dismissed, disposed of,
Today it was fixed for hearing actually.
disposed of.
As per
No, it's not come for hearing.
come from his order.
Order.
Para. A list along with the I stated to have been filed.
Obliged.
Please, sir, I apologize. I need some time, lordship. Actually, in this case, lordship, the appellant is a CRPF constable. He could not come to Gauhati to deposit the demand draft of rupees 7 lakhs. He was gathering the money. I did only 15 days time, lordship. Before 8,
Okay, what is your name?
A Borua, Anjali Borua.
Okay. This heard Miss A. Borough, learned counsel for the appellant. First of this appeal was admitted by the order dated 3/2/2026. And on the aspect of the prayer for stay of the impugned judgment, the The same, the same was done, subject to payment of, subject to deposit of rupees 7 lakh within a period of a month. Full stop. Ms. Barua? Yes, Mr. Ahmed, for which matter? This matter?
Yes.
Ms. Barua, the learned council has submitted that since the appellant is serving
In Manipur.
outside the state of Assam, he prays for some more time to make the aforesaid deposit. Full stop. Also heard Sri J. Ahmed, learned counsel for the sole respondent. Full stop. Para. Are you opposing? You're not opposing this. Who has not raised serious objections to the aforesaid prayer? Para. In view of the above, matter is adjourned, granting 4 weeks further time to the appellant to make the deposit in terms of the order dated 3/2/2026. Full stop. List on,
As a last chance.
list on today's 24 March. List on 27th of April. You get more than a month. You have
Let's see.
deposit.
Obviously.
And after deposit, it may be released to the.
First time, let them deposit.
Okay.
Rashid, this letter is going to take some time. Can it be taken up some?
Okay, we have to rise at 3 o'clock, otherwise you can complete it. But this bench is continued till Friday at least. It's your wish, or any other day.
Lordship, may on maybe on day after tomorrow.
Day after tomorrow, we have fixed a matter, but we can still try. Okay, we'll try.
Lordship.
On a joint request made on behalf of the learned council. Made by the learned council for the parties. Matter is adjourned to be listed on Thursday. Bakshi for which matter? Connected?
Seven.
Connected matter?
Yes,
Connected.
arising.
Same incident?
Same diary, yes.
Okay. Mazumdar is a regular appeal.
Lordship.
Bakshi Amekas. Okay, and the third one?
I'm in two cases,
Two
Lordship,
matters.
item number 6 and Lordship.
8.
Eight.
And for Sanjeev Sahu, Bakshi is there.
Yes.
Okay. Yes.
Of life.
May please, Lordship.
Yes.
In this case, Lordship, contacting counsel Mr. Ahmed is not well today, Lordship.
Who is not well?
Mr. Ahmed.
On a request made on behalf of Sri A. Ahmed Leonard Council for the appellant, matter is adjourned to be listed when?
Number 8 of April,
8th of April.
30,
Election.
after verification,
8th
Lordship.
of April is a dangerous date.
After verification, 30.
It's holiday.
Which
Wait
30?
for a bit.
No, we'll have in April. We can have it on 23rd?
How about 23rd?
23rd.
Yes. Oh, let's.
Will you?
Single beds, no? No single.
No, no, no. Single person, yeah.
Not.
You wanna say?
Yeah, 5,000. Criminal petition. No, I think part of it. I just thought it.
Which year, sir? November.
It's not person.
November he doesn't.
Well,
Aku find na ba? Kali kita kisah mulai
ইফালে মনীষতী ছাৰে বেল মাৰিছে তাতে উঠাব গৈছে তাতে বৰুৱা নাই ইফালে উঠাব গৈছে ইফালে আকৌ বেল মাৰিছে কি কৰে মই সেইটো কৰি থিয় হৈ আছো এতিয়া বৰুৱা বচন গৈছে ইফালে বেল মাৰি থৈ দিছে ইফালে মাতিব আহিল পিএছ কি ছাৰক উঠাই দিয়ক না বেল মাৰি আছে নাই আহিব কালি সেইকাৰণে কওঁ হেৰি হৈ থাকিব কাম এইটো পঠাই দিব ওপৰত